healthcare providers and members of the organizations known as Solutionist Thinkers and the National Healthcare Professionals Association made various allegations that they were being treated unfairly by medical schemes, and the basis for the unfair treatment was race and ethnicity. The Council for Medical Schemes launched an investigation. Parallel to this investigation was another investigation by the South African Human Rights Commission. The South African Human Rights Commission suspended its own investigation pending the outcome of the present investigation. What we have done in accordance with our terms of reference, we have produced an interim report. What we hope will happen is that stakeholders or those who are affected or generally interested parties will make comments on the interim report, tell us where we got things wrong, tell us where we could have got them right, basically tell us how we can make the final report better. So at this stage of the process, it needs to be stressed that although these findings, some people have described them already before they were released as strong findings, although they are strong findings, they are nevertheless interim. They may change depending on what evidence we receive in the next 6 weeks. We would like any comments to be made on this interim report to reach Mr. Tema, who is the secretariat of the panel, by the 1st of March. So that gives everybody about a month and 2 weeks, effectively some 6 weeks from now on. So what were the topics and what were the findings? There were two broad topics. And if you read the report, you will find that there are several subtopics. The first topic was whether or not in the way in which the medical schemes implement the statutory powers to investigate what is called as fraud, wastage, and abuse of resources, whether in the way in which they implement those statutory powers, there is evidence of unfair racial discrimination. That was the first question. The second question was, irrespective of whether or not there is unfair racial discrimination, whether there is procedural unfairness that the schemes can justifiably be accused of conducting when they implement those powers. On question one, which has generated the greatest public interest, unfair, this is what we concluded. One, if you got the media statement, you can go to paragraph 11. After considering all the evidence and responses, we have found that between 2012 and 2019, which is the period of the investigation, Black practitioners, and by Black I mean African, Indian, and colored, Black practitioners were more likely to be found to have committed fraud, waste, and abuse than their non-Black, in other words, white counterparts, by discovery, by meds, and by this means, in summary, that Discovery, MedScheme, and GEMS have committed unfair racial discrimination. We have not found explicit racial bias in the algorithms. In other words, an intention to cause discrimination. But using the data that Discovery, GEMS, and MedScheme provided to the panel, and as analyzed by Dr. Kimi, who was the expert employed by the panel, we have found that there are substantial differences in fraud, waste, and abuse outcomes between Black and non-Black practitioners over a substantial period of time, January 2012 to June 2019. What do we mean by that? One, over this period, across all disciplines, and what I mean by disciplines, I mean medical disciplines, and the aforementioned three schemes, Discovery, GEMS, and MedScheme, and their administrators, Black practitioners were 1.4 times more likely to be classified as having committed fraud, wastage, and abuse than those identified as non-Black. Two, the probability that this distribution occurred by chance, in other words, it was a mere accident, In other words, that there is no correlation between the racial status and the fraud, wastage, and abuse outcomes, which was one of the defenses raised by the schemes, is for all practical purposes zero. So to repeat this, we find that there is zero probability that the discrimination in outcomes occurred by accident. 3, the starkest differentials are evident from the following. In other words, the stark areas of distinction between Black and non-Black are evidenced by the following. 1, Black general practitioners are 1.5 times more likely to be identified as fraud, waste, and abuse cases than their non-Black counterparts. So you are 1.5 times more likely to be identified as having committed fraud if you are Black. 2, the rate at which Black physiotherapists, which is one of the classes of the disciplines, are identified as fraud, waste, and abuse cases is almost double. So it's double, 1.7 times than their non-Black counterparts. So there appears to be a disproportionate, even a higher disproportionate for physiotherapists. For Black psychologists, we find that they are 3 times more likely to be identified as fraud, waste, and abuse cases. For Black registered counselors and social workers, we find that those are also 3 times more likely to be identified as fraud, waste, and abuse cases. More than 50% of Black registered counselors have been identified as fraud, waste, and abuse cases. We find that this is the highest rate among the disciplines analyzed. And 5, for Black dietitians, we find the rate to be 2.5 times more likely to be identified as fraud, waste, and abuse cases compared to their non-Black counterparts. We also find that there are clear differences in the scale of racial discrimination between Discovery, GEMS, and MedScheme. So although we find that collectively, the schemes are likely to discriminate against Blacks on the basis of race, we also find that individually, the scale of racial discrimination differs. So in other words, it's not a blanket case. Even when it is individuated, there is a difference. What do we mean by that? 1, for Discovery, we find that they were 35% more likely to identify Black providers as having committed fraud, waste, and abuse. And this is the lowest rate of the 3 schemes and administrators we looked at. Discovery has the lowest rate of the likelihood of unfair racial discrimination. Number 2, GEMS is 80% more likely to identify Black providers as having committed fraud, waste, and abuse. MedScheme, which has the highest likelihood, is 330% more likely to identify Black providers as having committed fraud, waste, and abuse. So to emphasize the point, we find the schemes collectively are likely to identify Blacks as having committed fraud, wastage, and abuse. But we also find that individually, Discovery is 35% more likely to do the same, GEMS 80% more likely to do it, and MedScheme 330% more likely to identify Black healthcare providers as guilty of fraud, wastage, and abuse. We must emphasize the distinction. Of course, many of you may know that MedScheme administers many medical schemes, and its primary role is that of an administrator. But the mandate of the panel was to investigate the conduct of both schemes and administrators. Now, there was a contest by the schemes and the administrators to challenge the findings of Dr. Kimi, whom we appointed. Despite that challenge, the data remained, and I need to emphasize this, the data remained largely unchanged, and the picture of racial discrimination could not be disputed even by the expert evidence that was presented by the scheme. On MedScheme, if one assumes that their own expert methodology is correct, they are still 35% more likely to find Black providers guilty of fraud, wastage, and abuse. So in other words, if you discount the findings made by the panel and you look entirely on the report that came from Medscape, on that version alone, they are still 35% more likely to find Black healthcare providers guilty of fraud, wastage, and abuse. And you must remember that we found that the probability that this was by chance is 0. 2, on their own version, GEMS is 47% more likely to find Black providers guilty of fraud, waste, and abuse. And Discovery, on its own version, is 36% more likely to find Black providers guilty of fraud, wastage, and abuse. Discovery reduces the risk ratio, this percentage we've been talking about, to 1.09 on the basis of what it has described as confounding factors. Now, the way confounding factors were explained was that race alone is not sufficient. There are other technical explanations and sociological explanations or social factors that play a role. What we found, we rejected the confounding factors as being not credible. And so in other words, we subjected the confounding factors, in other words, the explanatory factors that were propounded by Discovery as not being credible. So when we have assessed all of the evidence, together with the application of unfair discrimination law, one must remember that the legal standard we use is from Section 9 of the Constitution. We were assisted in this assessment of the legal standard by Advocate Vemtrengov, who gave evidence before the panel publicly as an expert witness. We were also assisted by Professor Melissa Steyn from Wits University, who is also an expert on questions of race and society. So based on the assessment of the factual evidence, the expert report of Dr. Zaid Kimi, the expert evidence of Mr. Vemtrengov, SC, and the expert evidence of Professor Melissa Steyn, we came to the conclusion that there is an overwhelming racial discrimination in outcomes in fraud, waste, and abuse investigations conducted by Discovery, by GEMS, and by Medscape between 2012 and 2019. This amounts to unfair racial discrimination as defined in Section 9 of the Constitution, as well as in the Equality Act. Points of emphasis. This is an interim report, and these are interim findings. We have 6 weeks from today to enable each and every scheme that is affected to present further rebuttal of our report. We hope that the final report will be enriched by the submissions to be made in the next 6 weeks. In relation to the question of unfair process, in other words, the general unfair process, which is unrelated to race, what we have found is that the procedures that are followed by the schemes when they interact with practitioners generally, whether you are Black, white, or colored or Indian, when they implement their powers under Section 59 of the Medical Schemes Act, there is procedural unfairness. And the procedural unfairness is most profound when it comes to the absence of a hearing for a medical practitioner to dispute whether or not they have committed fraud. Sometimes an allegation suffices as proof. But there is also unfairness when a scheme decides on what amount to be clawed back or to be recovered. For those who do not know, typically when a scheme investigates a doctor who has made a false claim or an allegedly false claim, it will not investigate each and every claim for the past 3 years or the past 5 years. They generally make an assessment of the likelihood that the claims that you have submitted would also have been affected by improper practices. And thereafter, based on that generic assessment, they will impose an amount to claw back, to take back from the practice. Some doctors came to us and they told us at the panel, which was a public process, that the impact of these recoveries on their practices can be quite severe. One doctor said, my practice is 90% dependent on medical schemes. If they clawed back, recovered, took amounts from me, that would amount to a 90% reduction in my income. I have to close my practice. This is why it is absolutely crucial, not that fraud, waste, and abuse should not be combated. It should be combated. We agree with that fully. But it is crucial that when it is combated, the procedures that are followed are fair procedures. So a doctor needs to be given a fair warning about the allegations. They need to be given a fair opportunity to contest the allegations. They need to be given a fair opportunity, if they admit some of the allegations, to contest the amount that a scheme says should be recovered. This is what applies across the board in this country. This is what happens because it is required by Section 33 of the Constitution, and because it is required by the principle of legality, which also implies rationality in the way in which schemes operate. We have assessed, there were disputes, and most of you may not be interested in the final legalities, but the basic distinction was medical schemes saying we operate in the private sphere and we are therefore not bound by the rules of public law. What we have come to the conclusion is that even though one may say that medical schemes operate in the private sphere, they are nevertheless bound by the rules of procedural fairness because of the nature of the power that they hold. That power coming from the Act and the impact of that power on the public. I'll tell you what we mean about the impact of that power on the public. A doctor from East London, Dr. Ngumbela, came to the panel to give evidence. She came together with her patients. She told us that when she was put on so-called indirect payment or suspended from a medical scheme, the impact was not just on her in relation to her income, it was also on her patients, because it meant that she could not continue servicing those patients and they had to find an alternative doctor. If you are in a rural setting like the Eastern Cape or KwaZulu-Natal, finding an alternative doctor is not an easy thing. And so the impact of the conduct of the schemes goes beyond that bilateral relationship with a doctor, but it also affects patients and therefore affects accessibility of medical services to patients that ordinarily would not have access to those services. And hence we have emphasized in our findings that procedural fairness, which means telling a person what is the allegation against them, giving a chance to contest the allegation, telling them that you propose deducting an amount and conducting those conversations in an atmosphere that is non-adversarial and non-intimidatory. Some doctors complained of sheer intimidation by schemes, which makes them to simply submit to any demands by medical schemes. The final point to be made here is that medical schemes have stressed the significance of combating fraud, waste, and abuse as necessary to sustain their ability as schemes to continue providing the services that they provide. We have overwhelmingly endorsed this as a genuine concern and as something that this country, if anyone knows anything about South Africa, already faces a significant problem of enforcement of its laws. What we have been critical of is, although fraud, waste, and abuse ought to be tackled and it ought to be combated without hesitation and without equivocation, it is necessary that it must be done in a way that is not disproportionately impactful. In other words, innocent people should not be found guilty because the correct procedures have not been followed. So in sum, we emphasize that we had no power to find anyone guilty. We were not appointed to investigate the veracity of each and every individual claim of unfair treatment and unfair discrimination. But we would be failing in our duty if we ignored the degrading, humiliating, and distressing impact of racial discrimination against the individuals who testified before us. And part of our function was to provide a platform for the expression of individual experiences of racial discrimination and other forms of unfair treatment. We do not believe that we have covered each and every possible complaint by providers against schemes, nor was this our mandate. We also do not claim to have explored all possible manifestations of racial discrimination and unfair procedures. But we have received sufficient data and information to make informed and reliable conclusions of the patterns of conduct by the schemes. In certain respects, our conclusions, which are evidence-based, accord with individual experiences. Affirming these individual experiences as fact and as finding has been an essential element of the work of the panel, confirming that the majority of the complaints were not frivolously made. Our expectation is for a constructive engagement with the findings and recommendations of this report to ensue. We do not wish for hostility. We do not wish for acrimony. Rather than conclusive, our findings will hopefully provide a basis for the necessary reconstructive work. We must always remember that South Africa is still engaging with the consequences of apartheid, and we have only had 25 years to do so. We are still engaging with the consequences of colonialism. We have only had 25 years to do so. So what we hope is that our findings will provide the necessary basis for the reconstructive work which must be undertaken by the role players in the medical schemes industry. We are not in the industry. We are only 3 advocates. And so we were able to assess the conduct within the industry from an objective and non-interested perspective. We do not see this as a binary conflict between schemes and providers, but we see it as reflective of the fissures of the past that remain unresolved. Thank you, SJ. We shall take questions. My colleagues will answer the questions as and when they come. But SJ, you may facilitate the questions if you have access to all of the question and answers. This session should not be longer than, we are already at 10 to 12. We hope to have it closed by 12:15 because some of our colleagues have got other commitments for the day. Thank you.
Thank you very much, Advocate Ngaidobi. We are now going for questions and answers. We'll take about 3 questions, and the members of the panel will then attend to answer the questions. You'll do that by raising a hand, and I'll call by names as I see them coming up. Then I also want to announce that the summary is up on the website, and the report will also be put up on the website at 12:15. Karen, you're the first to have your hand up.
Thank you so much for having this briefing. Just to Advocate Ngaidobi and his panelists, obviously your release of this information today was preceded by an urgent application by the government employees medical scheme, which is the second biggest medical scheme in South Africa and represents government employees. Were you somewhat taken aback by that High Court interdict application? And how do you respond to a government body of that nature trying to block the release of your report?
Advocate Hassim will answer that.
Thanks, Karen, for the question. The answer to your question really lies in the affidavit that was filed on behalf of the panel in the case. But I don't want to avoid your question. In short, we were surprised because, as you may know, we had announced previously that we would release this interim report publicly, and that we had already provided significant opportunity to parties to comment on the substance of the allegations since July 2019. So we were surprised, but we also were not surprised with the ruling that was handed down today by Justice Collis. Does that answer your question?
I think you're being very diplomatic, but I respect that as an advocate. You probably don't want to really go into, the obvious questions around motive and the problematic dimension of a government body appearing to suppress a report on significant racial discrimination against Black healthcare workers. And yeah, I can understand why you might want to not necessarily go there.
I suppose what I will say is that, and you'll see this from the report, that we didn't make a finding of direct discrimination. We didn't make a finding of, deliberate racial discrimination, unfair racial discrimination. And as the chair pointed out, that this, we must also understand this in the context of our history, and that this is a function of our history and the society we all live in.
Thank you, Adila. We also have an SABC guest. The hand is up. It's written SABC guest. I can't identify the name there. You are on the floor, Sir Omeda.
Good day. I'm Sipho Stirman from SABC TV News. Just a quick one. You say that we had no power to find anyone guilty. So what I'm trying to find out then, with the outcomes of this report, obviously having observed some form of discrimination that takes place, then how is it actually going to help these Black practitioners? I've spoken to a number of them today outside the High Court, and they tell harrowing stories of discrimination. So with this report of yours, without having binding powers, then how are you likely to assist them? And of course, you mentioned that there are cases there of discrimination that seems to be, unfairly biased towards the Black practitioners. Are there going to be any consequences for these schemes, or will you recommend if there is any form of consequences? Because clearly this has an effect on some of the practitioners. Having observed some form of discrimination that takes place, then how is it actually going to...
Thank you. Esther, I think that perhaps Kerry should answer that question, and then you can move on to the third one.
Okay.
Thanks, Chair. That raises a very important question, again, as we've emphasized, for the systemic issues here. What we are trying to emphasize is that there is a complaints procedure in the Act, and it allows for Black practitioners to lodge complaints, and for that matter, white practitioners, and then for the council to adjudicate such complaints. So we wanted to be clear that we're not acting in terms of those provisions of the Acts, but that at the same time doesn't detract from the systemic findings. And we looked at, the data was made available to us over the past 6.5 years as to the outcomes of FWA by GEMS, MedScheme and Discovery. And when you look at the 6 years of experience, that is what we're drawing conclusions on. So this is a systemic assessment, and it is very important for that reason to understand what's been happening systemically for the last 6.5 years. In relation to the individual complaints, it's still for the doctors to pursue them through the Act. But that doesn't mean that when the report is made final, and depending on what those recommendations are, it won't be impactful, because we make recommendations to the council, and bearing in mind the amount of work and thought that's gone into it, we can only assume the council will take those recommendations and consider them carefully.
Could I add one consideration on this? This is an important question that the SABC is raising. You could take the view, if a doctor came, and which is what we had at the beginning of this inquiry, you have 5, 6, 7, maybe 10 doctors, black doctors, complaining about racial discrimination. So you could take the view that these are isolated cases, but that there is no structural or systemic problem. And that if I resolved them, I would realize that the problem goes away. I think where the report becomes important is what Kerry refers to as systemic. Because what we are able to validate through these findings is that these are not isolated instances of complaints by deranged practitioners, but there is a systemic problem of unfair racial discrimination in outcomes across disciplines, across schemes, and over a sustained period of time. This is data of 6 years. So that, I think, is crucial for the industry, because rather than looking at isolated cases that Dr. Ngumbela was treated unfairly, we've looked at the structural problem, and we come to the conclusion that there is, in fact, a structural problem, which means there should be reconstructive work within the industry itself, because these outcomes are almost inevitable if you have not resolved the systemic problem. So I think that's where the key distinction between our investigation is and a case where the CMS would adjudicate an individual complaint. The second area of addition to Kerry's question is that one of the problems that this country, certainly this industry, needs to grapple with is the exercise of statutory power by the Council for Medical Schemes. One of the complaints that came to us is that when complaints are made to the Council for Medical Schemes, individual doctors do not get relief timeously and appropriately. So it is also about strengthening the capacity of state bodies to enforce the law. Thanks, Astrid.
We'll go to the next one. Nelly Brand Jonker.
Hi, Charles, thanks. Maybe I've missed this, but if you say there's no evidence of explicit racial bias in the algorithms, then what caused this? Is this coming from the investigators, from people, not machines? I mean, what are you actually telling us?
Perhaps, Kerry, do you want to answer this?
Thanks very much for that question. So just to explain it, we looked at the data of the FWA outcomes that were provided by the three schemes, let's call them administrators. So that's a combination of algorithms and the investigative process and what it produces, who's found to have committed FWA. And we looked at those outcomes to see if they were discriminatory outcomes. So we haven't attempted to identify the source. It's partly because of the way the analysis works. You can't look at data and identify a source, although some of the schemes provided their algorithms. So, for example, Discovery provided their algorithm, and we could see that there was no factor in that algorithm which explicitly looked at race. But we haven't attempted to identify intentional discrimination in this. We thought it was more important to look at the systemic issue. I accept that it does matter why it's happening, but it's not something that we were able to consider.
Can I add to that, just to say that one of the recommendations we have made is that the schemes should conduct a racial impact assessment. It wasn't obvious, as Kerry pointed out, where the problem lies along the whole enforcement mechanism, whether it's a result of an algorithm being placed on a society in which there are issues that it just It can't take into account whether it's happening through the investigative processes within the administrators, whatever the case might be. We have recommended that the schemes and administrators conduct a racial impact assessment, and that might help to iron out some of the problems.
And if you don't mind, I'm also going to add to my own answer, just because yours has triggered a thought. But we've also recommended that the algorithms are made public, and if schemes or administrators use algorithms, that they know the factors, because that seems to be very important where machines are being involved in determining outcomes. It's important that the schemes and administrators know what those machines and their algorithms are doing.
And might I also say one more thing on this point and on the question of, is it people? So if you take a global view of the investigation, it is always a combination of people and machines. So that much is inevitable. If you then disaggregate the information that came before us and you look at the individual conduct of each and every scheme, so Discovery, which was most transparent with its algorithm, there you would not be able to find a factor built into the algorithm, which is racially discriminatory. But take, and you will see this in the report, take GEMS, for instance. At a certain point in time, the evidence that came before us, at a certain point in time in 2016, they were concerned about the spike, the increases in the cases of FWA across the country, but particularly in the province of KwaZulu-Natal. And a decision was taken to focus on that province. Now, if anyone knows that KwaZulu-Natal has a great proportion of Indian doctors, it is almost inevitable that once there is a policy decision taken by a scheme to place a particular emphasis on a certain province, there will be a correlation in outcome with race. The same thing as sometimes what we find is a decision is taken that a particular discipline, in other words, not geographic area, a particular discipline needs to be focused on because there is a spike in claims. So a discipline like physiotherapy or a discipline like psychologists. So there are those pockets of evidence, but you would need to go through that report quite carefully to pick those pockets of evidence where decisions are taken. Let's focus on KZN because there is a problem here, or let's focus on a particular discipline because there is a problem here. Those decisions often tend to show a correlation in the increases in outcomes. But if you are looking at, do the machines have a code that is racial or geographically biased, etc., that you will not find, but you will find a combination of factors. The final point on this is the unfair discrimination law that we are applying works on the basis of either intention or outcomes. No one ever admits that they were intent on being unfairly racially discriminatory. I've never seen such a case. But in order to conduct an objective assessment, you must look at the impact or the outcomes. And that is what we have worked on. So that is the premise of unfair discrimination law, which was presented by our experts and which has been the outcome of our own report. And so that's why it didn't matter to us whether the outcomes were intentional or not. What was necessary is that there was such a disproportion that a conclusion of unfair racial discrimination was inevitable. Esther, you keep switching off your microphone.
I was muted, yeah, I'm back on. Thank you very much. I still have one more question. One more person to ask a question, Lusani Mulaudzi.
Thanks, Mr. Tema, and thanks, Chair. Yeah, this is a very important report for us to reflect on cause and effect in our country. I'm wondering to what extent, and you may not have looked at this as you've indicated earlier, but to what extent has it to do with the complexity of having to claim from different medical schemes and perhaps the lack of support that some of our doctors have perhaps problems that creep in that process of claiming from medical schemes. Have you looked at that? Is that a hypothesis that you investigated or think should be investigated at some point?
Adila, do you want to take a stab on this?
Sure. Look, the report has considered all of those hypotheses. It's hard to make a finding in relation to it, but we did come to the conclusion that there is, one of the reasons for this disproportionate impact could be the lack of resources or the limited resources that are available to Black practitioners. And this is a complex area because it's not just about having assistance in making these multiple claims. It's also, as we would have heard during the hearings, about coding and how you cite codes on your billing invoices and what impact that has and whether you've chosen the right code or not. The other thing is that Black practitioners are more likely to be dependent on, their patients are more likely to rely on medical schemes making direct payment to the Black practitioners, to their providers, rather than paying upfront and then having to claim back from the medical scheme. So there are underlying socioeconomic factors, in other words, which is, I think, the question that you're pointing towards, that may have a very important role to play in the outcomes that we found.
Kerry, do you want to add anything? Yeah, I mean, I suppose, you've got to ask, Professor Melissa Steyn made this poignant point, which we cite in our report. If you want to engage with this meaningfully, you've got to ask yourself whether you are happy with a position that says Black doctors commit more fraud than white doctors. There's a statement. And that is why the outcomes are the way they are. Now, if you are happy with that as a general statement, then you've got to ask certain questions about yourself.
Oh, are you done? Okay.
Yeah,
we sitting at 12:10. I think we can take two more questions. I have Dr. Gumede's hand up. Dr. Gumede. Dr. Gumede. I'll take him later. I'll move on to Dr. T. Meti. Dr. Meti.
Hello.
Dr. Meti, the floor is yours.
I am Dr. Meti. I'm not sure.
Your hand is up for a question. Do you want to ask?
Dr. Meti from the Solutionist Thinkers Group. We are quite yes. I am Dr. Meti from the Solutionist Thinkers Group. We accept the. Can you hear me?
Yes, we can hear you. Please move quicker. We'll be kicked out of this in 5 minutes.
Can you hear me? I am
Yes,
Dr.
we can
Meti
hear
from the Solutionist Thinkers Group. Can you hear me?
Yes, we can hear you.
Okay. Okay, it's fine. We are happy with the findings. Yes, we are happy with the findings. My question is brief. I want to understand they are healthcare adversely affected by this abuse and racial discrimination. Who cannot actually live for them? I want to understand how agent will the recommendations be implemented by CMS, and some providers cannot even hold any. Thank you.
Tembeka, that's perhaps for you.
Oh, yeah. All right. Thank you. Okay, so who is supposed to implement? Most of the reform that we are recommending must take place within the schemes themselves. And it's not affecting the regulators. some work has already begun because we saw a drop in outcomes during the lifespan of this investigation. The numbers showed a significant decline. And particularly at Discovery, what we saw there that the appointment of the panel was having a positive impact because it was already leading to the drop in the numbers. So that work must continue. And there is not much that we as the panel can say to Discovery and GEMS and Medscape because they must do the reconstructive work internally. So that work has already begun. And then another group of people that must do something about the report is the CMS. Primarily, what the CMS ought to do is to provide individual relief to the individually affected doctors. So they need to encourage a process whereby individual doctors can lodge complaints and those complaints can be validated. And there is concrete action that can be taken. If monies have been deducted unfairly, they need to be paid back. If discrimination has occurred, appropriate remedies need to be followed, but the individual actions can take place through the CMS itself. And then the structural problems, which we think the Minister of Health will be interested in leading a process towards the resolution. So we see this as those multi-layers of finding solutions. I think SJ has been cut out.
I'm here. I'm here.
Oh, are you here? Okay. So,
I'm here.
Adila? Okay.
Sorry, yeah, just because, we make recommendations with regard to the regulatory entities. And apart from the CMS, the other important regulator is the Health Professions Council of South Africa. And because this goes, it goes both ways. There is a problem of fraud, waste, and abuse, and we shouldn't be misunderstood as underestimating the problem. Because the impact of any of that type of misconduct by practitioners is ultimately on the beneficiaries of the schemes. It's ultimately on the patients. So the financial impact. So there is a problem that needs to be addressed. And so the other entity I just wanted to say is the Health Professions Council, who has an important role to play in dealing with it from the perspective of addressing, misconduct or malpractice or improper practices where they occur.
Thank you, Adila. I had Kama. Does she still want to ask a question? She had her hand up. Kama.
Thanks. Hi, thanks. Tamar here from Business Day. I had a question about recommendations. I just wondered if you could clarify, are you making recommendations in your interim report, which we obviously haven't seen yet, or are you holding back on that until you have received comments from the affected parties?
Kerry.
Thanks. That's luckily an easy one. We are making recommendations and we're also seeking comment on those recommendations. So you'll see it in the report, which I'm sure will be up in the next 10 minutes.
Okay, I don't have any more hands up. It is 12:15. I guess this brings us to the end of our press conference. Thank you very much, colleagues. Thank you, the panel. We will close, as I said earlier on. The report will be up on the CMS website and the Section 59 website shortly after this. Thank you very much.
Thank you, SJ.
Sure.
Thank you, SJ.
Thank you, Adila. Thank you, Kerry. Thank you, Tembega.